Thank you, Mr. Chairman. Thank you, Mr. Chairman. Mr. Young, I'm a little confused. You referred to a department that doesn't exist. What's the name of the department that you're going to work for?
Sir, the name of the department is the Department of Defense.
Correct. Thank you. I appreciate that, and I think you must have slipped before in using that other name that has no legal basis. Mr. Young, you were the general counsel during the deployment of the troops of the National Guard to Los Angeles. What was the legal basis of that utilization of the National Guard?
Sir, the legal basis for that deployment to the National Guard is the President's Article II authority to protect federal functions and property, as well as the President's statutory authority under 10 U.S.C. 12406, sir.
And should there be a factual predicate for such a deployment, such a use of military force? And if so, who decides that the factual predicate has been met?
Well, sir, I would say that the statute is what the statute is, and it's written the way that it's written. That statute's been in existence and been utilized going back to the first president of the United States, George Washington, who mustered 19,000 National Guard personnel to march to Pennsylvania to suppress what was then considered the Whiskey Rebellion, where 500 people were tar and feathering tax collectors. And so the first president of the United States, as he looked at those set of circumstances, thought that the assault on the imposition of federal law and the execution of federal law was sufficient to muster thousands of National Guard personnel from all over the United States.
Is there any review of the President's decision in a case such as this to deploy troops? You cite the statutory basis. Is there any appropriate review of that decision, or is it a completely unilateral, unreviewable decision of the President?
Sir, I would say that matters in litigation before the Ninth Circuit Court of Appeals. The Ninth Circuit has issued a determination regarding the standard under which it would look at the President's factual determinations and gives significant deference based off of prior Supreme Court deference to the President in being able to ensure the execution of federal functions, the protection of federal property, and the protection of federal personnel as they're executing their duties.
Yesterday, Mr. Miller, counsel to the President, stated that the judge who ruled the deployment to Portland illegal and unconstitutional was a, quote, insurrectionist. Do you believe that a federal judge interpreting federal law as applied to a particular set of facts should be or could be declared an insurrectionist? That was the term he used.
Senator, I would say that a federal judge interpreting federal law as it relates to the execution of an Article II authority is exactly what our Constitution was founded on, and that's what we expect.
I agree with that, and I hope you'll convey that sound opinion to Mr. Miller. Turning to the recent strikes in the Caribbean, and I realize you're nominee to the Army, but you've been involved in these legal decisions. What's the legal justification for a kinetic strike against civilians in international waters?
Sir, the President, acting under his Article II authority, consistent with the powers that the Constitution has given him, has looked at the facts and circumstances regarding these drug cartels. The President considers these drug cartels to be non-state armed groups, which is what the President has designated them. He's designated them as terrorist organizations. He's looked at the facts and circumstances surrounding the manner in which the provision of narcotics and illicit narcotics have killed more people in the United States over the last 4 years than all of our conflicts in this century
Mr. Young, doesn't
combined.
the Constitution specifically delegate the power to declare war as opposed to be the commander-in-chief during a war to the Congress? And historically, we haven't been very good about declaring wars, but we at least have done authorizations of use of military force. Has there been such an authorization or any authorization by Congress whatsoever in this particular situation?
Senator, there has not been an authorization to my knowledge. I would say that the nature, scope, and duration of these activities do not rise to the level of war in the constitutional sense, and that the manner in which the President has authorized these strikes is consistent with both domestic and international
law. Does it raise any concerns with you that the President seems, you're asserting that the President has the power unilaterally to decide who's an enemy, to decide unilaterally that they can be killed without reference to any authority of Congress or any other restraint. If the president can designate somebody as an enemy combatant and then take that action, where does that stop?
Senator, that's a good question. I think those questions have been around since the beginning of drone warfare. I know in the Obama administration there were over 570 strikes that killed 3,700 people, many of whom were U.S. citizens abroad. And there were many questions that were presented to the president.
I believe that was subject to an authorization by the Congress, the 2001 AUMF. Thank you, Mr. Chairman, for the time.